Johnson versus the NCAA update here on February 15th, 2023. Welcome to a special episode 152 that we're dropping here Wednesday evening. College football's peek around the corner with your host, Greg Flugar. We cover everything in college football because we love everything in college football. And if you need that little bit of extra college football content to get you through the day, subscribe to our channel, smash that like button, share the video with your family and friends. This episode, 152, we're going to be giving you an update per ESPN, Dan Murphy. Johnson versus the NCAA. Our hearing was done this day, Wednesday. Now, why is this important? We'll go through the article, we will explain. But we talked about this all the way back in episode number 1, our manifesto here at College Football's Peek Around the Corner, as we try to give you a peek around the corner. We don't just predict next Saturday's football game. We try to predict what's going to happen, giving you the information you need and what's going to happen in all the changes that is going on in the college football landscape. It is why this Johnson versus NCAA and other court cases that are going to be coming up, it is why Texas and Oklahoma called the SEC together. It is why USC called the Big Ten in the spring. UCLA called Big Ten in the spring. It is why San Diego State and SMU is trying to jump over the wall to get into a Power 5 conference. It is why maybe years down the road, other schools in the ACC are going to try to jump over the wall to try to defeat their grant of rights. Yes, possibly, maybe. This stuff here, Johnson versus NCAA, that's why we're covering it. It may be a little too dry for some of you, but this is what we do here at College Football's Peek Around the Corner. We talk about every single thing in college football. Let's not waste any more time. Now, some of you agree with this, the Johnson part of this case. Some of you won't, but it's important that you know what is going down, what potentially could happen. According to Dan Murphy, ESPN, Wednesday hearing in front, this was out this morning. We're covering it here Wednesday evening. Wednesday's hearing in front of the U.S. Court of Appeals for the Third Circuit in Philadelphia is the next step in the Johnson versus NCAA case, in which several former college athletes argue they should have been paid an hourly wage like other student workers on their campuses. The NCAA contends that its business is unique. So far, the Supreme Court doesn't agree with that, but it is unique, and that the normal rules that determine whether someone fits the definition of an employee don't make sense for the college athletes. The appellate judges will eventually decide whether the standard tests for the employee status should be applied to college athletes and their schools. This particular case is flying under the radar compared to some of the others we hear about much more frequently, but it's important, says Sarah Wake, who advises university and athletic compliance issues in her role as attorney at McGuire Woods. Wake said the Johnson case is further along in its legal process. Keep that in mind. That's why we're covering the story. We are going to continue to cover the story at PATC. The case is further along in its legal process than many of the other threats facing the NCAA, although it's tough to predict which is most likely to deliver a major blow to amateurism in college sports. Each new threat increases the odds that some challenger will find a sympathetic ear with the power to force significant change. One of these things is going to stick, Wake said. It's only a matter of time before something goes in favor of the student athletes. By 2024, the college football playoff will triple in size, and the money's going to be gigantic, and the two most powerful football conferences in the country will officially welcome 4 of the sport's biggest brand names. Texas and Oklahoma will play the first season in the SEC that year, and USC, UCLA is scheduled to arrive in the Big Ten. Those changes were sparked and accelerated by the exchange of hundreds of millions of dollars. What is the Johnson case? Now focus on this. What is actually the Johnson case? Filed by former Villanova football player Trey Johnson, this case argues that college athletes fit the definition of an employee and have been denied rights that are protected in the Fair Labor Standards Act, FLSA. Those rights include making a minimum hourly wage and overtime pay. Plaintiff's attorney Paul McDonald said his goal is to give athletes the same kind of rights that fellow students who take the tickets or sell concessions to their games have when they are working for the university. All these years they've said you can't be both student and employees, but we've always had kids working on campus, working in the dining halls, libraries, and offices, working at the games themselves, McDonald says. They're trying to disadvantage athletes vis-a-vis other kids on campus. It seems fundamentally unfair to do that. The NCAA and its lawyers have argued in court documents that playing a sport in college is not work done in exchange for compensation. They say that is instead part of the educational experience for athletes on campus. To make athletes employees of their school, some members have argued is not affordable for most college athletic departments. NCAA members say they're open to modernizing their rules, but have drawn a hard line at calling their athletes school employees. In other courts, if other courts have already ruled in favor of the NCAA, what's the difference now? That is true. So far, the NCAA has won enough of these cases to keep the student athletes becoming employees of the universities. However, listen to this. The Ninth Circuit and Seventh Circuit courts have both ruled that college athletes are not employees protected by FLSA laws. Those cases, Dawson versus NCAA and Berger versus NCAA, concluded in 2019 and 2016 respectively. The idea of viewing college athletes as employees is less jarring now than it was even a few years ago, thanks in large part to the changes in name, image, and likeness rules. Other courts have also shown less deference in the past few years to the NCAA's argument that it's not like other industries. And most notably, here's the money shot of the whole article, and most notably, the U.S. Supreme Court, when it ruled unanimously that the organization was violating antitrust law in the June 2021 Alston versus NCAA case. The general sentiment has shifted in a lot of minds, sports attorney Mitt Winters said. In the past, it was hard to even think about college athletes as employees. And finally, the Supreme Court's decision in the Alston case, especially Justice Brett Kavanaugh's concurring opinion, opened the door to viewing the NCAA in the same light as other entertainment industry groups rather than an academic-focused institution, which makes every legal challenge the organization has faced since then a larger potential threat. The Johnson versus NCAA, it's steaming up, going in front of an appellate judge here on Wednesday. Hopefully we'll get some more information for you in the next few days and the next weeks and months ahead. This is an important case. We've been talking about this here at Peek Around the Corner. We believe that the presidents of all these FBS institutions should get out ahead of this. Make their student athletes employees. Somehow quasi-employees, somehow employees of the athletic department, or even a third party, but something to where these student athletes get to have a collection bargaining agreement, have them represented by some organization, some union, and then have a bargaining agreement with the schools and or conferences, probably the conferences, get some agreement so the student athletes are protected and the game is protected. The game that we all love, that we watch, that we go to the game, that we buy the t-shirts, the money coming in. These student athletes do not want their golden goose to be cooked, but these universities, they need to get into the modern era. These student athletes have to be treated in the same way the students do. It was true with the image, name, and likeness, and it's also true that students are employees of universities. They do work at times, their choice to work for the universities. These student athletes are working for the universities. They are employees right now, and they need to be recognized. And we believe here at Peek Around the Corner that these institutions know the change is coming by hook or by crook, by the Johnson versus NCAA case or other cases coming down the line. You can see what the Supreme Court believes. A unanimous decision, 9-0 vote. 9-0 vote on the Alston versus NCAA case, on the image, name, and likeness case. These universities know what's coming down the line. That's why Texas and Oklahoma went to the SEC. That's why USC wanted to go to the Big Ten, to afford their student athletes a potentially higher compensation going forward in the years ahead. That's why Oregon and Washington keeps knocking on the Big Ten door. That's why San Diego State and SMU is trying to get over the wall. And that's why, look, if student athletes become employees of the universities, there are going to be other court cases. There are going to be other challenges, potentially to potential conferences owning grantor rights of individual schools. Put down your comments. Put down your thoughts in the comments section below the video. I know many of you do not agree with the student athletes becoming employees of the universities. I used to have that opinion years ago. It has changed. But it doesn't matter what I think. The Supreme Court, you can tell where this is going. You can feel it, you can sense it, and more importantly, these schools believe that that's where it's going, that's where it's heading. Yeah, NCAA is going to fight it, but eventually they're going to lose. So these presidents, in my opinion, need to get out in front of this, create a different organizational body to represent the universities and the conferences, and let the student athletes be represented by their whatever organization, college athlete student organization that they come up with. Let's get this going. Let's make this game better for everybody, especially for us fans, the consumer of this game, and of course the student athletes. Put down your comments. Let me know what you think. Let me know how wrong I am. But we're going to be following here this Johnson versus NCAA. This is what we do here at College Football Peek Around the Corner. We cover everything in college football, including this most important court case up in front of the appellate judges today, Wednesday, February 15th. Until next time, from all of us at Peek Around the Corner to all of you, please, you all take care of each other. Thank you so very much.